Good evening. My name is Yasmin, and together with my group members, our presentation will examine how the legal test for dishonesty has evolved over time, specifically from the Ghosh test to the Ivey decision, and how this change has influenced the prosecution of theft and fraud offences in the United Kingdom as well as the Malaysian law. And lastly, we'll be suggesting possible reforms for Malaysia's approach for dishonesty. Dishonesty is a central concept in determining both criminal and civil liability, especially in offences such as theft, fraud, and breach of trust in both English and Malaysian law. In England and Wales, theft is defined under Section 1 of the Theft Act 1968. The physical elements of theft are straightforward. The mental element of dishonesty has long been debated. Courts have sought to clarify whether dishonesty should be judged based on an individual's own belief or by the standard reasonable person's belief. This issue was initially examined in the case of R against Ghosh in 1982, which introduced a subjective and objective test, which was mixed. However, this was later rejected in 2017 by the Supreme Court decision in Ivey and Genting casinos, where the court adopted a fully objective standard. In the case of R against Ghosh, Dr. Ghosh, a surgeon, submitted 4 claims to recover money he believed he was owed for previous work. The key issue was how to define dishonesty, as the Act did not provide a clear definition. The court had to decide whether Dr. Ghosh's action amounted to dishonesty under Section 15 of the Act. Lord Len rejected a purely objective test, reasoning that the defendant's own knowledge and belief must be taken into account when assessing dishonesty. The court set out a 2-limb test. First, the jury must decide whether the defendant's conduct was dishonest by the standard of reasonable and honest people, which is the objective limb. If so, they must then consider whether the defendant realized that what they were doing was dishonest by those standards, which is the subjective limb. However, the Ghosh test soon proved problematic in practice, as it often led to confusion. Its application could also produce preserved outcomes, as individuals who did not understand ordinary and socially acceptable standards of honesty could escape liability by claiming that they did not personally see their actions as dishonest. In Ivey against Genting casinos, a professional gambler, Mr. Ivey, used a technique known as edge sorting to gain an advantage. The Supreme Court, led by Lord Hughes, reconsidered the meaning of dishonesty in English law. Although the case was about Section 42 of the Gambling Act 2005, the court went further, criticizing the Ghosh test for establishing confusing and for allowing defendants with distorted moral standards to avoid liability. Lord Hughes rejected the subjective limb of the Ghosh test and introduced the new objective standard. Under this approach, the court must first determine the defendant's actual belief or knowledge of the facts subjectively, and then decide whether, in light of those facts, the conduct was dishonest by the standards of ordinary decent people objectively. There is no longer any need to reconsider whether the defendant personally realized their actions were dishonest.
My name is Divya, and I'll be evaluating the strengths and weaknesses of both of these tests. As explained earlier, the test of Ivey removes the subjective limb to the dishonesty test. This ensures greater alignment with the objective standard of conduct. This prevents unconventional moral standards from becoming as a means to escape criminal liability. Moreover, this test ensures predictability. Lord Hughes in Ivey and Lord Nicholas in Royal Brunei Airlines and Tan noted that the juries no longer have to concern themselves with the confusing second limb of Ghosh, where it can produce inconsistent results with unclear reasoning. Additionally, following the Law Commission report on fraud and dishonesty, they tend to be more favorable towards the Ivey test. This is because the new objective test allows the law to be more uniform, clearer, and easier to be explained to the jury. They also noted that retaining the subjective element of Ghosh would risk inconsistency and manipulation. However, the Ivey test shifts the test for dishonesty towards a conduct-based standard rather than assessing the defendant's moral culpability. Professor William argues that removing the subjective limb detaches dishonesty from the defendant's moral understanding, creating the risk that someone might actually be convicted even if they genuinely did not realize that their conduct was dishonest by ordinary standards. Furthermore, Professor Hodder argues that the Ivey test punishes people who simply fail to understand society's standards rather than those who deliberately go against them. He disagrees with the Ivey's test and believes that the law should keep the subjective element, especially since criminal liability affects personal freedom. Lastly, the objective test weakens the mens rea requirement, turning dishonesty into a factual finding about behavior rather than about the culpable culpable mindset. The Ghosh test kept a clear moral standard. By removing the subjective element, Ivey shifts the focus to whether the conduct would be seen as dishonest by an ordinary and reasonable person based on the facts that the defendant believed. While this change makes the law more certain, it can also reduce fairness to those who genuinely misunderstood. Overall, Ivey promotes consistency and simplicity, but still allows judges to consider the defendant's circumstances and context, striking a fair balance between fairness and clarity. So, was removing the subjective limb a good thing? In our opinion, yes, because Ivey brings greater clarity and consistency to the law. It prevents the defendants from escaping liability by just relying on their own distorted moral views and ensures fairness is brought to society.
My name is Danya, and now I will be diving into the impact from the subjective-objective test in Ghosh to the wholly objective standard in Ivey, which has altered how these offenses are prosecuted. Now, before the shift to Ivey, the subjective limb in regards to the Ghosh test was deemed a bit problematic for the prosecution, as the defendant's belief in the facts often created a shadow of doubt in juries' minds, especially in cases related to fraud or theft. Under Section 1 of the Theft Act, dishonesty lies as a key element to establishing criminal conduct for theft. Virgo made note of whether the shift from Ghosh was appropriate to convict a defendant of an offense without needing to prove the guilty was aware their conduct was wholly objectively dishonest. It was noted in most cases this would have not made a huge difference to the result, as the jury would conclude that no defendant would believe a reasonable person would have recognized their conduct as dishonest, or because the defendant's belief as to the facts, the jury would consider their conduct as honest. The impact of Ivey may be prevalent in offenses like theft, as dishonesty is key in rendering conduct to be criminal. An increased emphasis was placed on the element of dishonesty, which was brought by the earlier decision of Gomez, where consent was violated by the defendant's dishonesty and was later influenced by Hinks, where a lawful valid gift could be considered as appropriation if the act in itself was deemed dishonest. Therefore, most of the heavy lifting of the conviction of theft is placed on dishonesty. Previously, when the Ghosh test applied, the belief that a reasonable person would consider their conduct to be honest provided a form of a safeguard. Now, with these safeguards diminished, as established in Barton, the conviction of theft depends on whether an ordinary decent person would regard their conduct dishonest unless their conduct falls within the exceptions provided by Section 2, subsection 1 of the Theft Act. Now, theft is considered to be a crime that requires neither proof of harm nor subjective fault. Similarly, dishonesty appears as a key element to prove criminal conduct under the Fraud Act. Prosecutions have now been streamlined by the Ivey test, as dishonesty is now judged solely against the community standard, making it harder for defendants to escape liability by appealing to subjective beliefs. This distinction of how Ivey has played a role in creating a uniform standard of dishonesty can be seen in the case of Agunas, where it was debated whether their conduct of opening a bank account using another person's driving license mounted to dishonest false representation in Section 2 of the Fraud Act. If the present case was tried under the ruling of Ivey, the question would be whether an ordinary decent person would regard the conduct of using a false ID to deceive a bank as dishonest. There are fewer defenses to be relied upon, as there is less room for maneuver, like in Hayes and another, where the defendants were insistent on their personal belief on the standard industry practice. After the implementation of Ivey, it had allowed the courts to consider whether ordinary people would consider their acts to be dishonest. The impact of Ivey has now allowed for easier jury directions, but this may allow for a risk of over-criminalization, as the objective test may have expanded criminal liability unfairly, especially where the defendants have a lack of awareness.
Greetings, my name is Fatin. Now the question is, where does Malaysian criminal law for dishonesty stand? So today, I will demonstrate that Malaysia follows its own unique statutory path, examine the significant impact it has on our legal system. Unlike in England, Malaysia's definition of dishonesty is not judge-made, it is codified in our penal code. It is a test based on legal rights and not public morality, and it is governed specifically under Section 23 and Section 24 of our penal code, and states that an act is dishonest only if there is an intention to cause wrongful gain or wrongful loss. Wrongful means here defined that it is based on objective legal standard, which whether a person was legally entitled to the property. Our courts have consistently affirmed this statutory test, like in the case of Yap Singh Hawk and public prosecutor, is a perfect example. The court's entire analysis was based on the penal code's definitions of dishonestly and wrongful gain, and there was no reference to the Ghosh test or the standards of ordinary people. The court just simply asked, Was the act unlawful and did it cause a wrongful gain or loss? This principle is also seen in theft cases like Sun and Fook and Regina. The accused was acquitted because he had a genuine belief that he had a legal right to the property. This reinforces that the core of our test is the violation of legal entitlement and not a breach of public morals. So to be clear, Malaysia follows neither Ghosh nor Ivey. We don't follow Ghosh because we are not concerned with whether the accused realized the act was dishonest by public standard. And while our test is structurally similar to Ivey, our objective standard is different. So Ivey uses the moral standards of ordinary decent people, whereas Malaysia uses the concrete legal standard of legal entitlement. Now, what is the real world impact of our test? Let's compare its practical outcomes to the UK Ivey test. So firstly, the Malaysian test can be seen as fairer to the defendant in certain situations. This is best illustrated by the case of Sun and Fook against Regina. And so in this case, the accused was acquitted because he had a genuine belief that he had a legal right. This claim of right defense is powerful in Malaysia because if the accused genuinely believes they are legally entitled to the property, they cannot have the intention to cause wrongful gain or loss. This contrasts significantly with the UK's Ivey test. The Ivey test applies an objective standard of honesty. A mistaken belief about one's legal right might not be a defense if an ordinary person would still find the conduct dishonest. The second practical impact is that our test rigidity raises the risk of under-criminalization. Because it is so closely related to the property and legal entitlement, it may be less adaptive to new or complex criminal acts when the harm is not a direct loss of property. So the UK's broader morality-based Ivey test may be better effective in detecting these revolutionary sorts of criminal or misconduct.
I'm Hannah, and I will now evaluate whether Malaysia should adopt the Ivey objective test or instead retain and reform its current statutory model. Thus, the issue is not simply how Malaysia differs from Ghosh and Ivey, but whether our definition remains fair and responsive to contemporary misconduct. So, should Malaysia adopt the Ivey objective test? The English approach in Ivey replaced Ghosh two-limbs test with a single moral inquiry. This promotes moral accountability. However, Malaysia should not adopt the Ivey model as it rests on moral subjectivity, not legal entitlement. Malaysia's multicultural and multi-religious context offers no single ordinary moral standard. It is immensely subjective and difficult to ascertain. As scholars have said, the Ghosh-Ivey model creates a fiction of community norms that cannot deliver consistency in plural society. This moralized model undercuts the concept of mens rea by punishing according to moral estimation rather than legal culpability. Applying to Malaysia, such a model would erode penal code's objective foundation, where law and not moral opinion defines wrongdoing. Australia provides a useful model for Malaysia. Although the Commonwealth Criminal Code 1995 initially adopted a Ghosh-style definition of dishonesty, the High Court in Peters and the Queen rejected that approach. The court returned to a claim of right legal entitlement standard, holding that a person is dishonest when they are acting without a belief in legal entitlement. Dishonesty should turn on legal and economic detriment, not shifting moral sentiment. The inquiry is legal objective. Did the conduct cause unjust impairment of protected interests even without direct property loss? Accordingly, Malaysia can emulate this Australian development by incorporating a fairness safeguard within a legal entitlement framework. Our recommended reforms include: instead of importing Ivey, Malaysia should retain its statutory core. First is to broaden wrongful gain and loss in Section 23. Amend the definitions to cover digital and intangible properties such as data, cryptocurrency, and online credit. Non-proprietary advantages including confidential information, business opportunities, and so far as reputational value. Second is to implement two-tier legal fairness tests. First, primary legal entitlement test determines whether the accused intentionally caused unlawful gain or loss, which is the current statutory standard. The secondary fairness check is where no direct property loss exists. Assess whether act caused significant practical detriment to another's lawful or fiduciary interest. Third is to implement judicial directions on application of dishonesty. Even with an extended statutory definition, courts require practical guidance for applying sections 23 to 24 in complex factual scenarios. Malaysia could introduce judicial directions or statutory explanatory notes outlining how judges should instruct fact finders when dishonesty is an issue. These directions should clarify how intentions to cause wrongful gain or loss is to be proved, how wrongful detriment to lawful interest is assessed under proposed fairness tier, and when a dishonesty direction is necessary. This is essential in Malaysia because there is no jury system. Trial judges act as the sole triers of facts and law. Malaysian judges cannot resort to communal morality as a benchmark.
Thank you, Hannah. In conclusion, the Ivey test made dishonesty in English law more consistent, but risked unfairly punishing those unaware of their own wrongdoings. On the other hand, in Malaysia, dishonesty under Section 23 and 24 of the Penal Code is clear, but it's too narrow for modern issues like digital or trust-related misconduct. Therefore, we believe, instead of adopting the Ivey test, Malaysia should update the Penal Code to expand the definition of wrongful gain or loss, add a fairness test for non-property harms, and guide judges for clearer and fairer decisions. Thank you.